Dear colleagues, dear participants, we have arrived to the end of our today's conference. And I would like to invite you to share with us your comments or questions related to the subject of today's event.
Hello, I have a question for Professor Savic. Can we talk about violation of child right on privacy if parents baptize him and then he don't have opportunity to be erased from that database? And I also have one question for Professor Dragicic-Petenjača. I want to ask how we can protect child from the parents and how to define the best child for best child interest, because even if we do something that we really believe it will be helpful, it could be bad decision for child, and it is any possibility to create guidelines for institution to help that determine the best child interest.
Thank you for this question. So I'll try to make a long story short. Under many conventions which are treating child's rights, parents are responsible and still are major elements of child's education and choosing the worldview. There are decisions of the court in this respect. Parents still, not the state, father and mother, have a right to choose the religion of a child, to choose in which sport club he or she will go, to choose which kind of education and what will be the worldview of this child. All of us here are actually, there are many discussions about that. It's a discussion about determinism and indeterminism, how we are, our thoughts, your thoughts, my thoughts, are ourselves, or they are thoughts of our parents, of our ancestors, of our grandmothers, or people who were surrounded us when we were young. Important thing to say here is that if parents are choosing to baptize a child, it can be any other religious ceremony. It's an act of the moment. It doesn't mean that the child doesn't have to follow the religion after the child becomes a woman or man. But what happens sometimes, that children decided because of the revolt, depart from the parents, but in 5, 6, 7 years they want to come back. They realize that their parents were right and they belong to that community. Just thinking, if you would allow erasing from the documents, and then this person in 5 years decides to come back to the church, he's not there anymore, and you cannot baptize this boy or girl twice, because he was already baptized, but the fact that he was baptized cannot be erased. For instance, marriage. You can divorce. Something happens in 20, 30 years, you don't like your husband or wife anymore. But the fact that you were married, you cannot erase history. You know, just pushing too much on some issues will make, I would say, ridiculous situations. The fact that you were married in the church and that for the church you were married forever cannot be changed. The historical moment happened. You loved each other once, but something happened. You know, you cannot undo your history. GDPR is not there to undo your history, to make public documents not valid, or I would say in the public documents, like church documents, if they are public documents, they are there to make life of citizens easier. For instance, maybe you like your name, maybe you don't like your name. Your parents choose your name, not the state. Maybe you dislike your name, but you cannot come and say, you can change your name, but you cannot erase your name from the day of your birth, because it's your birth certificate, it's a public document. Sorry, you don't, bad luck. You don't have a nice name. But, you know, that's life. You know, frustrations sometimes lead to very evil movements. And of course, law is here to heal, but law is not here to make even more mess. That's my point. Law is to make order, not to make mess, because somebody doesn't like something. Thank you.
Thank you. It's a very tough question, I have to say. First, I would like to distinguish two different things. If the parent in any sort commits criminal offense of any kind toward the child regarding his or her privacy, then he is responsible and actually will held liable for that criminal offense. So that's one level of protection. You are protected for if the parent commits criminal offense. Okay, that's one level. The other level is this that we are talking about, and it's more of protection from your invasion into your privacy by your parents, which is not criminal offense. That is not regulated. And as you say, and you stated, should there be some guidance? Yes. Who will bring this guidance? I don't know. Because who is here to decide the best interest of the child? It cannot be done on the level of the legislator, but each parent has to do it for their own child. The best interest, I have also children, and the best interest for my girl is not the best interest for my son. So I have to choose, and I have to decide what is the best interest of my girl in some cases, and what is the best interest of my son. Therefore, we are the only one who can do it. But what can be done is that we raise awareness towards the parents that they are responsible for their own children, and that they have to think more in future what their children will be, or maybe they will not be satisfied with. So if I think that, and if I say, I think it's safer not to publish that picture, because I don't know how my child is going to react in 5 or 10 years from now, then this is the real decision. Because in Croatia there are, as I stated, 83 complaints toward a child's ombudsman, but this is not the main authority for dealing with this issue. There is Data Protection Agency. And Data Protection Agency actually decides upon if the privacy of the child has been violated. Therefore, this is only one mean to this conclusion if the violation has been committed, let's say if the privacy of the child has been violated. Therefore, it's very tough question. I think that we can do only through education. Only through education and to raising awareness that some things that we have to think further in the future of the best interest of our child. There is no very simple solution. As David also said, what to do with this stuff, it's not very easy to do it. I'm sorry to say it, there is no very simple solution. I don't know if I helped you or not. And regarding this issue, I would like just only to add, this is not only GDPR question, because this is very interesting question of whether there are remedies for dealing with this situation. If there are not remedies, then the GDPR cannot be only applied, I want to be erased, because there is no mean to be erased, right? You don't have any mean to be erased in this grounds, yeah. Grounds. You don't have remedies, you don't have complaints, you don't have any legal means to do it. So I don't know if I'm helping or I'm unhelping and more complicating things. Thank you.
So just to add one more thing about the best interest of the child and about the assessments. Put it on. Okay, thank you. So I would like to add that the Committee on the Rights of the Child has published 2 different comments, well, lots of them, but 2 are especially relevant for this issue. And the one concerns the right of the child to have his or her best interest taken into consideration. And one of the most recent one concerns the rights of the child in the digital environment. And both of them contain some universal guidelines to be considered while discussing this subject.
Well, I would like to have 2 remarks. The first concerns the best interest of a child, since the problem is to how to approach it. It's always a matter of perspective. And to give you an example, our Constitutional Court dealt several years ago with a case which concerned a couple who got married in California, I believe, according to the law of California, and the couple was consisted of 2 males. And they had a baby. One of them was actually a father, the other not, of course. There are some limits which the law cannot, overcome. But no one knows which one is the actual father. They were just enlisted in documents related to the child, the birth certificate, both as parents, as fathers. Well, and they came to the Czech Republic, as one of them was a citizen of the Czech Republic, and they wanted to have their marriage and also the fact that they are both parents, both fathers of the child, recognized in the Czech Republic for many practical reasons. Well, and as I said, the case ended at the Constitutional Court, and the question is, well, what is the best interest of a child? According to our Constitutional Court, is to live in harmony, in love, in a family, and there the Constitutional Court ended, and thus, allowed the recognition of this situation, although it is not possible, it is not legal, it would be against the public moral in the Czech Republic. But the other approach is, well, isn't it better for the child to live in a normal family and to know who his mother really is and who is his biological father? And that's the question. I know, according to our constitutional judges, the first option is in the best of the interest of the child. And myself, I don't agree, but I'm not a constitutional judge, of course, so that's a problem. Well, and another thing concerns the last topic. It reminded me that the wording of the Article 16 of the Treaty on Functioning of the European Union. Since we all approach GDPR as a regulation of general application, and that's of course also the canon supported by the case law of the Court of Justice. But I still think that this is a wrong approach, since that article, that provision clearly states that the protection should be secured within the scope of EU law. And for example, the church and its functioning is clearly out of the scope of any activity of the European Union. But as I said, the general approach, and I'm fully aware of it, is that the GDPR should apply almost to everything. Yeah, but it's... You agree or disagree? Well, that's with what I disagree, since I think that the wording of the article must be there on purpose. We don't have any limitations in different areas, for example, of social policy, but here there is a clear word within the scope of EU law. So that's a limit, and this limit must be taken into account, but it's not in practice and in case law of the Court of Justice. Thank you.
Just a brief, thank you. Just a brief comment. Well, I was trying to be to concentrate myself on this very important thing, that church books are public books. If they are public books which have significant importance for functioning of society and actually for state affairs, then they do not fall into the GDPR. Because as you know, you cannot, I was answering previous question, you cannot go to state registry and say, please change the fact that my name was, I'm not mentioning any name, I didn't like it. Yeah, no, I'm not doing this. So, you cannot change historical fact. It's just, law has to be rational. You know, and I think the law in the world we live today is too many times used for clashes, I would say clashes of worldviews, of particular agendas, political, cultural, and so on. Lawyers have to remain rational, and we have to use our brains to do what we think is right. What you said about Constitutional Court of Czech Republic, I also disagree with this decision. Because what is love? Is it a legal argument? I openly speak about this. I ask my students, in Croatia, there is no marriage between same-sex couples. I respect them. I think everybody has right to live according to his or her views. But in Croatia, marriage is union of man and woman. It's constitutional. There are civil unions, they can have communities, but they are called civil unions. I try to be very open to my students. We discuss some, when we talk about values and when we talk about hierarchy of norms in terms of values. Who is applying the norm? Of course, somebody who is applying a norm and his values can be important. I'm not saying are always, but can be or could be important. And then some students, and that's fair, say, well, professor, my opinion is that marriage between man and man, woman and woman, should be allowed because state, who is the state to interfere in love or love? I said, okay, fair enough. But tell me, would you agree that 3 men have marriage? Or 4? Oh no, professor, don't go that far. Why? Why? If love is the argument. Or would you allow that cousins, the closest cousins, go into matrimony? No, come on, professor, you're exaggerating. Come on, love. If love is who can define love? And if love is the main argument, then we have to allow everything. But obviously, there are some values. There are some public morals. There's something which makes us society and community. I'm not saying that in 20 or 30 or 50 years, things will not change. Who knows how this society will look like? But we are making laws as a reflection of values which exist today. Professor Weiler, sorry for taking so much time, but this is important, said, professor from NYU, he's a Jewish believer who was actually arguing for Italy in Lautzi case where there was a question if crucifix can be in the classroom. Interesting, a religious Jewish guy defending crucifix on Italian walls. He said, maybe one day, something, I'll try to be as correct as I can. It might happen that British people will decide to change their anthem, God Save the King. Obviously, many of British people who who are British do not believe in God. But they don't accept that you change British anthem. It's God, God save the king. And those who do not believe also sing because it's part of their identity of being British. But who knows, in 20 or 30 years, British people will decide to rewrite their national anthem. But leave this to British people. Don't interfere. Thanks.
Hello, Tomasz Dusan. I would like to change the topic for a moment. And I've got a quick question to the Dr. Oremziak about the right of the privacy on the ground of the Polish constitution. Like, Doctor, what do you think? How do you see the development of the right of the privacy on the ground of our constitution and in the realm of the development of the technology? I mean that we've got a lot of applications that are gathering, for example, biometric data. And of course, it is illegal on the ground of the GDPR, but still, maybe should we wait for the EU to implement AI Act, some legislation about artificial intelligence, about the right to privacy due to these problems, or should we put some effort on our own national legislation on this topic? Thank you.
So thank you very much for this question. It is a very interesting also about the EU regulation that is proceeding at the European Union. This is the proposal of the Council of Europe, of course. Sorry, the European Commission, of course. But I think that the content of the right to privacy should be firstly protected by the national law. About the constitutional laws, that is a basic basis about the protection. We have measures in a civil law, in administrative law, criminal law, but the most important in our constitution. And in my opinion, this basis should be at the first level of the implementation. We should care about this, and EU Regulation Act is maybe good step for some regulating matter, but I'm thinking about the, some competence of the European Union to regulate right to privacy. I have to think about this, and in my opinion, this is the matter restricted to the national laws, exactly the constitutional law. And in Poland, we have a basis, we have measures indicated in a constitutional law. So according to the development of the new technologies, we should, in my opinion, monitoring and developing our national measures and preparing them to the new challenges. Yeah? So, because in my opinion, standards of the right to privacy, despite the time we are talking about, so this is the 21st century, we have new technologies, artificial intelligence, a lot of these items, but the basic fundamental principles and rules are the same. The right to privacy, in essence, not changing, because it is about the environment of the appearing of the right to privacy. In a traditional life, we developed a lot of principles and rules. The same is in a new technologies environment. So, in my opinion, I firstly would look into national legislation to bases that currently are in our national laws, and after that, when something is missing, we can talking about the new legal framework, and if there is a need to some cooperation between states, there is a request for such organization like European Union. And this is my answer. Thank you.
So, if there are no more the questions and comments, let me extend my gratitude to all of you for your attention and your valuable contributions. I would like to thank the Hungarian Academy of Sciences for hosting our event. And last but not least, I would like to thank colleagues from the Central European Academy for coordinating the conference. Thank you.